Attention, everyone. The meeting will begin in 3, 2, 1.
Good morning. I now call the meeting of the Code Enforcement Special Magistrate to order. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome to the Hillsborough County Code Enforcement Special Magistrate hearing. When addressing the magistrate, please state your name, address, and speak clearly into the microphone. If you are planning to speak during this meeting, you must sign the speakers list located at the front door so your case can be called. Any person who decides to appeal a decision of the Code Enforcement Special Magistrate will need a record of the proceedings. The record is comprised of testimony and evidence upon which an appeal is based. It is your responsibility to ensure that a verbatim record of the proceedings is made. By law, you have 30 days from the date of my order to appeal my decision to circuit court. Presentations by the county, respondents, and opposition must be kept to a maximum of 10 minutes each. Special magistrate may recess at 12:30 and reconvene at 1:30 to conclude its business if needed. The basic process for this hearing is as follows. Ms. Meyer will conduct the oath of witness. Your case will be announced. Staff will present the evidence on your case, and then you will be allowed to rebut that evidence and explain what has occurred. I will close the hearing and announce a decision. I may ask questions and allow other witness testimony if necessary. Depending on my order, the county staff may later have to conduct an inspection to see if you have complied. If the staff believes you have not complied, you'll receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against your property. For false alarm or water resources cases, if you have not complied by paying the past due burglar false alarm fine or the water resources penalty fine within the time ordered, you will receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against your property. If you have any questions, these rules are outlined by Hillsborough County Codes of Ordinances and Laws, Chapter 14, Article 2, Section 14. Before we begin, please silence all electronic devices. First order of business, I move and approve the minutes for September 21st, October 8th, and October 15th. And we are ready for the oath, Ms. Meyer.
All county staff who will be testifying must take the oath of witness. Please stand and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. First case, ready?
Yes, ma'am.
First case is on page 1 under Water Ordinance Cases, number 3, case number WR 2101814. The owner is Lee Douglas Hawkins Jr. and Ciara Wright Hawkins, 12244 Legacy Bright Street. We have service, and I understand someone is online virtually for this case.
Yes, Ciara Hawkins.
One moment. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. Please state your name and address.
Ciara Hawkins, address is 12244 Legacy Bright Street, Riverview, Florida, 33578.
Thank you.
Go ahead, Carmine.
Okay.
One moment, Ms. Harkins. We'll do the testimony of the officer first.
Okay.
My name is Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2101432. On Friday, 5/21/2021 at 6:58 hours, Officer Paul, On Wednesday, this is the case of WR 2101814. On Wednesday, 6/16/2021 at 6:58 hours, Officer Ted Baker arrived at 12244 Legacy Bright Street to observe the sprinkler system watering the front yard. This is a watering day, but during the restricted watering hours. A notice of violation was sent out on 6/18/2021. The fault letter followed on 7/26/2021. Notice of hearing was posted by Officer Whaley on 10/19/2021. There was a previous violation on 4/20/21, case WR 210766, where a warning was issued. The fine in this case is $100.
Okay, Ms. Hawkins, what would you like to tell me?
Yes, so, I was confused about the notice because I have my sprinkler system switched off, to get to the borough permit. I contacted Ted, Baker, and I was kind of confused because that day I ran my water around 10:30. I manually switched it on due to the prior, warning back in April. So, but being on the phone with him about 20 minutes, he went through it step by step with my system, and apparently he said they still have set days and times on the other days. I was supposed to switch and turn those days off as well. So after the confusion was cleared up, I asked him who I need to speak with to get the $100 waived, and I contacted Hillsborough County Water, and then they told me to email someone else. And by the time I sent the email, I never heard anything back. I went out of town for a month, came back, and I came to this for the violation court hearing, and here I am today pleading the case. So that day I ran my
Understand.
water twice and wasn't aware at that time 6:58 it was being ran because I wake up around 7:30 to get the kids ready for school. And like I said, I went in the garage and manually turned it on at 10, I think it was 10:40 or something like that, because between 10:30, I believe, and 12-ish you can run it. And at night, I never run it at night. It's always in the morning.
Well, that's good. Carmine, you said there was a previous violation, there was a warning issued,
Yeah, yes, sir.
and the date for that?
On 4/20/2021. 4/20/2021.
Okay. Ms. Hawkins, what happened on April 20th of 2021?
Honestly, like I said, that was probably my fault there. And that's why I started to do just to manually shut off and I turn it on manually. I don't let it run automatic anymore because of that warning back in April. I can't really tell you honestly what happened back in April. And maybe that was on me. That's why going forward, I had manually shut it off thinking that it shouldn't run, but obviously it did back in June as well. And that's when Mr. Ted Baker had explained to me the process of how to go to each day to make sure it's actually off. Because I
Okay.
didn't want those issues for future references.
So you think you've got the issue taken care of for the future then?
Yeah, definitely. Yes, definitely.
And I appreciate you coming online this morning, but you're telling me that you're not going to see me anymore.
No, no, sir. No, sir. I want to do
Okay.
right. Yeah, I want to ignore
All right.
this issue.
Well, because of the warning that was issued in April, I can't waive the fine, but I will reduce it by 20%. So I'll make the fine amount $80 instead of $100.
Okay.
And then I'll give you a couple extra days to pay that as well, since you came online this morning, and I appreciate you explaining to me what happened.
Okay, I
And then we'll go from there. And then the good news is you got it squared away and you're manually doing it, so there shouldn't be any future violations, correct?
No, sir.
Awesome. Okay, I will go ahead and rule then. Thank you for coming out.
Thank you. That's all for today.
I rule.
Okay.
Yes, ma'am. As soon as I rule, just if you want to hear it, you're more than welcome to stay around to listen.
Okay.
I ruled case WR 21011814 that based on the evidence presented, I find the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7 Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I grant the violator 45 days to make the water penalty fine, to pay the water penalty fine imposed, or if payment is not made by that date, a fine of $20 per day be assessed. I also adjust the penalty fine amount from $100 to $80. All right, ma'am, you have 45 days to pay that fine.
Absolutely. Thank you so much. Enjoy your day.
Thank you, so you too. Next case, please.
Next case, please back up to number 2, case number WR 2101684. The owner is Mitchell Antoine Dominique, 7827 Carriage Point Drive. We have service, and I believe someone is here for this case. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? And make sure that microphone is turned on. I don't think so.
There you go.
Okay, there you go.
Yes, ma'am.
And state your name and address.
My name is Antoine D. Mitchell, 7827 Carriage Point Drive.
And the rest of the address, please.
Gibsonton, Florida, 33534. Sorry about that.
It's okay.
And I apologize, we got your name out of order there. We gave Dominique as your last name. We'll fix that.
It's okay.
Mr. Pisano,
Yeah, hold on, my
no problem.
computer has decided. Okay. I am Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2101684. On Tuesday, 6/8/2021, at 5:47 hours, Officer Paul Whaley arrived at 7827 Carriage Point Drive to find a sprinkler system on, watering the right side of the driveway. This is a non-watering day during non-watering hours. A notice of violation was sent out on 6/10/2021, followed by the default letter on 7/26/2021, and the notice of hearing was posted by Officer Whaley on 10/19/2021. There is a previous violation on 5/14/2021 in the case of WR 2101341, and a warning was issued at that time. The fine for this offense is $100.
Excellent. Sir, what would you like to tell me?
It sounded like I heard there was two different separate offenses that take place.
There was a warning issued back in May, and then there was this violation in the first week of June. Correct.
I really don't have nothing to say, but I bought this house in December, and I didn't know when you buy the house in the subdivision I stay in, they cut the irrigation on to come on at 5 o'clock in the morning. I'm never outside, so I didn't even know. But I just paid the $100 fine yesterday.
Oh, okay. So you already took care of it.
I took care of it yesterday, but
Oh.
I still need to come in.
Fantastic. Okay. No problem. Do you have the ability to adjust your times?
I just cut it all the way off because grass finna die anyway. So
Gotcha.
I just cut
No.
it all the way off. Now,
I understand. Okay. Well, no worries. I will go ahead and rule, and I'll give it 30 days so that the paperwork washes out because you've already paid the fine, but shouldn't have to worry about it if you've already paid it. So you'll get a notice. Awesome. Thank you, sir. I rule in case WR 2101684 that based on the notice presented, the violator has failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7 Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I grant the violator 30 days to pay the water penalty fine imposed, or the payment is not made by that date, a fine of $15 per day be assessed. Next case, please.
Turn to page 6, number 11, under landscaping and natural resource cases. Case number L216615. The owner is Alexis Vasquez and Anna P. Vasquez. The violator is Signature Tree and Home. Address 11712 Carrollwood Cove Drive. We have service, and we have someone here for this case. Good morning. Raise your right hand, please.
Yes, that's a matter because they're not. And I'm Nelson Borges, and I'm gonna,
Excuse me, sir. Sir, raise your right hand, please.
yes,
Do you swear or affirm, right hand up?
yes,
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
yes, it will be. the whole-
Okay, and now state your name and address.
Yes, I'm Nelson Borges, and I'm 3004 Storybrooke Reserve Drive, Odessa, Florida, 23625.
Okay, and you're representing the Vasquez?
Yes, ma'am.
Thank you.
Good morning, Ms. Hall.
Morning. Krista Hull with the Development Services Department. This is case L216615. Property owners Alexis Vasquez and Anna P. Vasquez. Violator Signature Tree and Home. Violation address 11712 Carrollwood Cove Drive, Tampa. Violation observed, unpermitted removal of one live oak tree measuring 21 inches DBH. Ordinance violated is section 4.01.03A. First inspection, February 4th, 2021. First notice, February 11th, 2021. Last inspection, September 23rd, 2021. 3 inspections conducted. On January 2021, there is an inspection that was made. This is a picture of this tree before it was removed. It was taken from the Google Street View. It shows a 21-inch live oak tree in January. The tree has been replaced by the property owner in regards to putting in a 1.5-inch magnolia tree on February 4th, 2021. However, that does not fulfill the code requirements for full replacement of an unpermitted tree removal. No further replacements were found on the property on September 23rd, 2021 by the inspector, Wayne Doyen. So staff recommendation will be that the violator plant or donate 18 inches DBH of approved shade or ornamental restoration trees or contribute 18 inches to the restoration fund or combination of plantings or contribution to the fund within 60 days. Trees must be at least 1 inch DBH or larger, a minimum 8 feet in height, Florida grade 1, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the restoration fund equates to $65 per inch. The violator's signature tree and home will be the responsible party for resolving this matter with the county. We recommend removing the property owner for they have fulfilled the landscaping requirements on their property. Fines will be issued for failure to meet timeframes.
Okay. Sir, what would you like to tell me?
Oh, we never
Can you
intended.
do me a favor and tip
Yes.
that down just a little bit that way
Yes.
so my
I
recording
apologize.
folks back home
I
can get
apologize.
that? Thank you.
I apologize, sir.
No, that's fine.
Yeah, man, the Vasquez never intended this. I mean, it all started with basically a failure to communicate. It was a trimming for the neighbors that wanted to trim the tree. And it all evolved in the cutting of the tree. It was never intended to cut the tree in the first place. The tree company definitely decided to do that. Even evolved in the favor of Mr. Vasquez was not intended to, never consented to that tree. And so the company did all what happened, and that's why they got cited. I don't know if they're here or not. And it all comes to show, you get on to that. We even went into the sport of the statute, tended to the pruning and trimming, all that, because we even found that we got the photos on this. We even found damage under the sewers and the sprinkler system that was damaging all that, that at the end, we were supposed to, Mr. Vasquez was supposed to get even the permits. Eventually, we were going to have to remove the trees eventually to get all that fixed, that we would have to come to the county to get all that fixed and get the permits. So if the tree company would have waited for us to get the permits to do the right thing, none of this would have occurred. So we would have endorsed the county to at least give us a time to would have done all this, it would have done been correctly. So we endorsed the county to give us the time to get all this fixed and avoid all those hefty fines in order to fix all this. So we endorsed the county to at least be reasonable with the Vasquez on here and work all this together so we can try to get and endorse the commission and the magistrate to be lenient here to work this all together so we can, because they did all this together to try to fix it. But it was not on their side, because when Mr. Vasquez did all this, he was not even on their, he even has a doctor's notes and everything that suggests that he was never in the capacity to consent for the tree company to do what they did at the time. And I had the photos and I have the doctors, and I will submit this if I'm allowed.
Okay. Yeah, the young lady will take it from you. Just to be clear, you hired, the Vasquez's hired the signature tree and home to do the work?
No, it was hired by the neighbor to do the trimming on.
They
the
were just
tree
trimming
because
their
it was
side
other-
of the tree
yeah,
and they
it was
ended up
other-
taking down the entire tree on the Vasquez's property?
Yes.
Okay.
That's why the company was cited here today as part of the violation. The notice hasn't included also, Your Honor.
Ms. Hull, you've been in contact with the Vasquezes, and that's why we're going solely after the violator on this, correct?
Yes, sir.
Okay.
And Your Honor, it was supposed to be a trimming, not a cutting of the tree.
Wow. Okay. I'm really sorry about Mr. Vasquez's health. I appreciate you submitting that to let me know.
And again, we endorse, I mean, we don't mind working with the county, fixing all this and getting it right this time because they never intended to do that. I mean,
It sounds like the county believes that Signature Tree and Home should get this right for you. So,
I know.
okay. All right. Terrific. Was there anything else you'd like to add, or I'd be happy to make a ruling based on that
No,
testimony?
No,
Okay.
this all submitted.
Okay. I rule in case L 216615, the basis of the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the activity of the violator, and the violator's history, I concur with staff's recommendations and require the violator, Signature Tree and Home, to plant or donate 18 inches of DBH of approved shaved ornamental restoration trees or contribute 18 inches to the restoration fund or a combination of plantings and contribution to the fund within 60 days. Trees must be 1 inch DBH or larger with a minimum of 8 feet in height and Florida grade 1 chosen from the Hillsborough County approved tree list as appropriate. Contribution to the restoration fund equals $65 per DBH inch. The violator, Signature Tree and Home, is responsible for resolving this matter with the county, and I order that the owner, Vasquez, be removed from this order. Fines will be issued at a rate of $275 a day. Excellent.
Thank you, sir.
Thank you, sir. Appreciate you coming out. Thank you. Have a great day. Next case, please.
Turn to page 7, number 14, case number L 216750. The owner is ALA Group Investment Incorporated, 4815 Ridgepoint Drive. We have service and we have some parties signed in for this case. If you're here for this case, please come forward. Good morning. Raise your right hand, please.
Yes, speak English. I was trying to translate.
Okay. He needs to take the oath of witness, so please, and if you would take it too at the same time, that will be fine. You can come up and stand by him. Both of you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your names for the record and addresses, and speak into the microphone. He can say his name and address in the microphone.
My name is Augusto Tan. My address is new. 1 second, please.
He did change his address.
No problem. We'll take new.
Thank you, sir. It's 18107 Peregrines Birch Place, Unit 304, Tampa, Florida 33558.
Thank you.
You're welcome, ma'am.
And state your name and address, sir.
My name is Santiago Fernandez. My address is 8754 Mala Reserve Drive, Unit 202.
And the rest of the address.
Oh, okay. The zip code is 33614.
Okay, thank you.
Ms. Hull?
Krista Hull with the Development Services Department. This is case L 216750. Property owner and violator is AL Group Investment Incorporated. Augusto Tang, president. Violation address 4815 Ridgepoint Drive, Tampa. Violation observed, unpermitted removal of a laurel oak tree measuring 38 inches DBH. Ordinance violated, section 4.01.03A. First inspection, March 18, 2021. First notice, March 31st, 2021. Last inspection, October 19, 2021. 3 inspections conducted. March 18, 2021, Wayne Doyne was on the property and identified the unpermitted removal of a 38-inch laurel oak. October 19th, follow-up inspection showed no tree replacements in the front. There is a new maple in the backyard. However, it does not meet the county standards for compliance. Staff recommendation is that the property owner and violator plant or donate 38 inches DBH of an approved shade ornamental restoration trees or contribute 38 inches to the restoration fund or a combination of planting and contribution to the fund within 60 calendar days. Trees must be 1 inch DBH or larger, Florida grade 1, minimum 8 feet in height, chosen from the Hillsborough County approved tree list as appropriate. Contribution to the restoration fund equates to $65 per DBH inch. Fines will be issued for failure to meet these timeframes.
Okay, Mr. Tang, what would you like to tell me?
I will try to speak in the name of Mr. Tang, okay? He's the landlord of that house. He has the person that he's living there. Mr. Tang never allowed that cut of the tree. He get notice about this cut when he received the first letter from the county. He also was out of the country when the person that lived now here cut the tree. He never cut the tree. He never allowed that cut. We also approached to the person to say, oh, what happened? Why did you cut it without permission of the county of my permission? And he said, I will take in charge of any things that maybe any fee or penalty. Mr. Moore, Matt Moore is the one who's living there, and he's responsible of this cut. He's only the owner of the house. He don't live there.
Mhm.
And he's very concerned about this because we have many conversations with Matt Moore. He's the responsible of this cut. And Mr. Moore told to us that he's dealing with this with the county, and he also said that he have the relation of tree that he have to buy and replace, and what the restoration fund fee that he have to pay. But at this point, we, Mr. Tang, don't know what is going with all that. He's very concerned about this because he doesn't speak English, and he's very, very, very concerned.
Mhm. Okay. Ms. Hull, it sounds like the testimony is that this has been done by the tenant and not by the owner.
Yeah.
Unfortunately, the property owner is responsible for what his tenant does.
Yes.
He'll have to resolve that with his tenant after resolving this with the county.
Excellent. Does that make sense?
Yeah, it has sense for me.
Yeah. So, I mean, you'll have to go after them legally or through your, rent or something. I'm not quite sure how you would handle that, but because it's your property, that's who we deal with on this particular case. You'll have to find another way to resolve that with your tenant.
Okay.
That make sense?
Yeah.
Sure.
All the sense. Thank
Okay. Well, Ms. Hull, are you okay with maybe extending your deadline a little bit to give them a time to do that?
Well, how much time does he need? We have 60 days here.
Fantastic question. Right now, it's the recommendation of the county to complete that work, either restoration of the tree or planting the DBHs that's required, or a contribution to the fund within 60 days. Does that work for you guys?
Yeah, of course.
Okay,
Thank you.
excellent. All right. I rule in case 216750 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, concur with staff's recommendations, require the owner to plant or donate 38 inches DBH of approved shade ornamental restoration trees, or contribute 38 inches to the restoration fund, or a combination of planting and contribution to the fund within 60 calendar days. Trees must be 1 inch DBH or larger, Florida grade 1, minimum of 8 feet in height, chosen from Hillsborough County approved tree list as appropriate. Contribution to the restoration fund equates to $65 per DBH inch. Failure to meet these timeframes listed above will result in a penalty of $150 per day. So you have 60 days to complete the work. Okay?
Yeah, thank you.
All right. Thank you very much.
Turn to page 8, number 16, case number L216845. The owner is Durham Bowen and Marlene Bowen, location 20006 Daytona Way. We have service, and someone is here for this case. Good morning. Raise your right hand, please.
Good morning.
Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
And state your name and address.
Durham Bowen, 20006 Daytona Way, Tampa, Florida, 33647.
Thank you.
Thank you, Mr. Bowen. I'm going to ask if you could leave your mask up for me during
Okay.
Thank you. Appreciate that. Ms. Hull?
Case L216845, property owner and violators, Durham Bowen and Marlene Bowen. Violation address is 2006 Daytona Way, Tampa, Florida. Violation observed improper pruning resulting in the effective removal of a required street tree for the subdivision live oak preserve. Ordinance violated is section 6.06.05.d. First inspection, April 29, 2021. First notice, April 29, 2021. Last inspection, October 19, 2021. 3 inspections conducted. The first inspection was done by Wayne Doan on April 29, 2021. Property owner effectively removed the live oak tree by topping the tree. This will lead to the tree going into shock, creates water sprouts, which will grow weak connections. Topping the tree will also create large stubs, which will have a difficult time compartmentalizing and will become vulnerable to insects and decay. Topping the street tree causes hazardous conditions for the pedestrians utilizing the sidewalk and a road in the proximity of the tree. On October 19th, Wayne Down went to the property. He found that the live oak does have some rigorous regrowth, which are water sprouts, which are weak attachments that can be hazardous to the street and the sidewalk. Staff's recommendation is that the property owner plant 1 county-approved street tree within 45 days. Trees must be 1 inch DBH or larger, a minimum of 6 feet in height, Florida grade number 1, chosen from the Hillsborough County approved street tree list. The violator, Durham Bowen and Marlene Bowen, are responsible for resolving this matter with the county. Fines will be issued for failure to meet the timeframes.
Good morning, sir. What would you like to tell me?
Well, I brought a few pages of documents I'd like to submit.
Okay.
Okay.
Young lady will grab them from you.
Well, thank you for the opportunity to address the matter shown in the July 26, 2021 letter I received shown as alleged violation of the Land Development Code on my street tree. This letter from the Development Services also stated that the DSD staff has not received my written response regarding corrective action on this matter. Also included was there would be no hearing if in compliance by August 10 this year. Indeed, I submitted at least 3 responses directly to Mr. Wayne Doyen's office, in addition to a comprehensive response I sent to my Live Oak Preserve Association. My Live Oak Association was the first to advise me in writing on April 28th of this alleged violation, I was given details specifying why the tree must be replaced. Later on September 21, I learned from Mr. Doyen that this was not a quote HOA violation, but a county violation. My HOA did provide specifications for compliance, and my response to my HOA pointed out the reasons why I should not be held guilty of this alleged violation. While I'm not sure which piece of the evidence, some of which I try to have copies made available to you, is more important than the other, I'm kindly disputing the alleged violation. To acknowledge the fact that this tree is not dead, was never dead, is not expected to be dead, and that the tree is doing well as other trees in the area, I would like to refer to a few of the documents in the file folder I submitted. On chart, I think I have them in order. The chart on page 2 of my response to my Live Oak Association, which when I thought it was just from them, I didn't know it was from the county, dated May 12, 2021. This chart shows a comparison between the compliance or the stated remedy conditions which I should meet against the then current tree condition. Secondly, I would like to also refer to my one-page response to the department service, the Development Service Department, that is, dated on 9/20/21. This reiterated some of what I wrote to my HOA and also shows additional tree improvement. Let me quickly read because this is at the heart of
Mr. Vogt, let me stop you right there. I don't want to hear about any of the other properties or other tree conditions. I'm only dealing with your tree condition.
Okay.
So I saw number 3, but that doesn't apply to you. So I want to stay focused on this particular case. Okay?
Okay, in this particular case, the delivery utility and maintenance vehicle, this is for the reason why the tree was pruned. And I usually prune the tree every few years. I've been living there since 2011. But delivery and utility maintenance vehicles, I've been finding it difficult to park or drive under the tree or through the tree leaves, overhang, tree limbs overhanging. And during the early months of this year, I took notice of tall trees trimmed along in the area, managed by the management. And in recent months before that, Mr. Doyen pointed out that my neighbor had violated the ordinance by cutting the tree. And I pointed out, yes, I know, because I told him that he shouldn't have cut it that low, and he still did. I told him he might die, and he still did, and I wouldn't have done that. Anyway, even another, well, you don't want to hear about the neighbor up the road, but it's the same.
And you're more than welcome to call the county to talk to them about other violations in your neighborhood if you want to report them. But that's fine. But that's not what this particular case is about. Is it your testimony, sir, that your neighbor cut your tree and did what's shown in that picture, or you did?
No. I cut the tree myself, but it was not pruned to the point where it was considered. It's not even in the park. It has 8. You saw the picture.
Did you see
that? 8. I saw the picture. I had the picture. It has 8 limbs on it.
And that's your tree, sir, correct?
Yeah, limbs and branches. It's not just water sprouts. It has 8 limbs and branches. We saw that. There it is. if you count it, there were 8 limbs and branches on there.
Yes, sir. Did you prune it to that condition?
Yes.
Okay, see, that's the concern from the county, is that that tree is not going to survive, even with branches. All it has now is water sprouts, so it's not a healthy tree, so it needs to be replaced. It needs to be removed and replaced.
Well, based on the picture and based on the pictures I submitted, you can see it's not all water sprouts. I left several limbs on there with branches which came off the 8 limbs that I left.
Right.
And
Unfortunately, for a live oak, it's too traumatic to have that kind of pruning. It's not going to survive. So-
Have you seen the pictures I submitted?
Yes, sir. They're right here. This tree?
Yes, that one.
Yes, sir. Those are just water sprouts. That's not the original tree. Those are just water sprouts.
Well,
That's the tree trying to reach out after being literally scalped.
right, I understand that there are a lot of water sprouts, but that's not the only thing. You can see there's several limbs and branches on there which have grown because the growing season started and the regular branches that were left on it grew. And then, of course, because it was pruned, there are lots of water sprouts.
Yes, sir.
But one of my problem with this is I had no idea that pruning the tree to that extent that I did would be a problem, because I was not. Someone told me we should have gotten some kind of a package from the HOA when we bought in 2011, so that we know the regulations. I knew nothing about that until the HOA sent me this, and then was followed up by Mr. Doyen coming by. I knew nothing, so there was no reason for me to know and not cut my tree, even though common sense told me that I should not cut it as my neighbor did, which killed the tree.
Ah, so there was common sense there.
Of course, that's what
Sure.
I use common sense,
Mhm.
because my neighbor almost killed his tree
Mhm.
and he had to replace it.
Mhm.
And I would never have done that.
But you
I
saw the
reported
condition,
beforehand.
sir, you saw the condition next door. You
Yeah.
saw that they had to replace it.
It
You
was
did this,
replaced, yeah.
sir, you did the same thing to your tree.
No, I didn't.
You did not.
No, he didn't. I did not do the same thing to my tree. He really cut his tree.
He really did it. You just kind of did it.
No. You could see the picture. The picture tells the story. He almost killed this tree.
Sir, you have killed this tree by the pruning. It's not going to make it. So I understand what you're saying, sir, but the picture of the water sprouts is not sufficient to say that you're not responsible for replacing this tree. So what I can do is I can help you maybe with a little bit of time to get it done, but I don't see anything here that leads me to believe that you're not responsible for this particular tree.
I'd like to just make a short closing statement here.
Sure.
Let me jump to what I've been thinking.
Mr. Bowell,
That the water sprouts that naturally grew after the pruning, along with the leafy branches already there, newly grown, give the tree a full canopy look, and the tree has limbs and branches with leaves that keep it healthy and looking good. I do have, I'm sure some trees are over pruned, but I think mine is outside of that category. So I'm asking you, sir, the board, to please consider the facts presented. I don't have to, so I don't have to try getting a loan from the bank to pay for a violation that my wife and I would have to pay for,
Yeah, I understand what you're saying. And as you mentioned in your testimony, that you're not an expert in tree pruning. However, the folks from the county, the folks that are on our staff that have done this presentation are. So I'm going to turn it over to Ms. Hall or whoever went out and did the initial review so they can explain to you why that tree is not going to make it. Okay?
I understand.
All right, hold on one
main
second.
point was that I was not aware.
I understand you weren't aware, sir,
It's
but
not-
still,
it's not
you're-
the expertise.
sir, at the end of the day, you're responsible for everything on your property. So I'll be happy to let Ms. Hall explain that to you, why that tree is not going to make it.
Okay,
Then we'll go from there.
all right.
thank you.
Mr. Powell, you have effectively removed the tree. It may not die, today or tomorrow, but it will eventually die because you have removed its upper canopy, which what allows this tree to thrive. It's not just its root system, it also thrives through its leaves, and the leaves are removed. Now it tried to survive, and it's coming out with water sprouts to try to survive. Unfortunately, this leaves the tree in a weaker and a hazardous state. It becomes a liability. This is a county right of way. We have to consider the liability of that tree now. It's more weak, it's more prone to lose branches and cause property damage. Those have been liability cases that the county is aware of. So unfortunately, we cannot ask you to keep that tree there. We need to ask you to replace that tree. We're only asking you to replace it with one county-approved street tree at a minimum size of 1-inch trunk diameter and 6 feet in height. So if 45 days is not sufficient time to find that tree, please let me know so we can recommend another time frame.
If I have to replace the tree, and it sounds like that is what the ruling will be, is that I would have to do it myself, and I'm sure 45 days would not be enough, because I'd have to remove it, cut it up, dig up the roots and all of that. Otherwise, we can try and get a loan to have a professional have it done. But I could do a fairly professional job if I have enough time to do it.
Would 60 days be sufficient?
I hope it will.
Okay.
Okay. We can help with that. Okay, I'll make a motion. I rule in case L 216845 that based on the evidence presented, I find the property is in violation from Hillsborough County Codes of Ordinances listed in staff's presentation. Further, based on the granted violation, the action taken by the violator and the violator's history. Concur with staff's recommendations and require the violator to plant one county-approved street tree within 45 days. That tree must be 1-inch DBH or I'm sorry. I said we'd do that, and I skipped right over it. Let me revise that. Require the violator to plant one county-approved street tree within 60 calendar days. Tree must be 1-inch DBH or larger with a minimum of 6 feet in height. Florida grade 1, chosen from the Hillsborough County approved street tree list. Violator Durham Bowen and Marlene Bowen are responsibility for resolving this matter with the county. Failure to meet these timelines result in a penalty of $150 per day. All right, sir, so you have 60 days to complete that work. After that, it's $150 a day.
Could we, if it's not done in exactly 60 days, may I contact the office?
No, sir.
No?
60 days.
So could it be anything more than 60 days?
No, sir. I've already ruled. It's
You have already ruled?
60 days.
One last question. Do you have any
Sure.
idea? According to my neighbor, it was over $900 to replace it. Do you have any idea roughly how much?
I do not. I'm not in the street tree buying business, but you might want to ask one of the officers, or you might want to contact a nursery or something to find out
Okay.
what that would be.
All right. Thank you.
You're welcome, sir. Thank you.
There's no one else in the audience. That was the last person.
Okay.
So we'll go back to the beginning of the agenda on page 1, under water ordinance cases, number 1. Case number WR 2101432. The owner is Sun Yun Hong, 10323 Boggy Moss Drive. We have service and no one is present.
I am Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2101432. On Friday, 5/21/2021 at 6:58 hours, Officer Paul Whaley arrived at 10323 Boggy Moss Drive to find the sprinkler system watering on the right side of the driveway. This is a non-watering day during non-watering hours. A notice of violation was sent on 5/26/2021, followed by the default letter on 7/26/2021. Notice of hearing was posted by Officer Paul Whaley on 10/19/2021. And to make note that there was a previous violations on 4/2/2021 on the case WR 2100607. A warning was issued for the watering violation. There is a case prior to this on May 10th, 2021, 5/10/2021, in the case of WR 2101103. That was a $100 fine, and it was set for a hearing on 9/21/2021, but it was pulled for lack of services and now reset for 12/10/2021. This being the third violation at this location, the fine is $200.
I rule in case WR 2101432 that based on the evidence presented, violators failed to pay the water resources penalty fine for illegal sprinkling imposed by section 111-7 Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I grant the violator 30 days to pay the water penalty fine imposed, or if the payment is not made by that date, a fine of $30 per day be assessed.
Turn to page 2, number 4, WR 2101823. The owners are Rebecca Leslie Martha Gilbald and Kyle Anthony Singleton. Location 10603 Avian Forest Drive. We have service and no one's present.
I am Carmine Pisano with Hillsborough County Code Enforcement. This is the case of WR 2101823. On Thursday, 6/17/2021 at 6:32 hours, Officer Ted Baker arrived at 10603 Avian Forest Drive to observe the sprinkler system watering the lawn on the right side of the driveway. This is a non-watering day during non-watering hours. Notice of violation was sent on 6/21/2021, followed by default letter on 7/26/2021. The notice of hearing was posted by Officer Whaley on 10/19/2021. There's a previous violation on 3/17/2021 under the case WR 2100420, where warning was issued for the watering violation. And I will note that on 7/29/2021, under the case of WR 2102092, there is a future hearing under another violation at this location. This incident results in a fine of $100.
I rule in case WR 2101823 that based on the evidence presented, the violators failed to pay the water resource penalty fine for illegal sprinkling imposed by section 111-7 Hillsborough County Codes of Ordinances and Laws, Part B, Public Utilities. I grant the violator 30 days to come into compliance. I grant the violator 30 days to pay the water penalty fine imposed, order if that payment is not made by that date, a fine of $20 per day be assessed.
Okay, that concludes the water cases. And I understand someone is waiting online to testify. Let's
Okay.
see if we can get them on the screen.
Angela, are you there?
Yes, I am. Can you hear me?
Yes.
Okay, turn to page 3 under landscaping and natural resource cases, number 5, case number L 205-895. The owner is William Rudder and the violator is Jimmy's Tree Service Incorporated, 16117 West Lake Burrell Drive. We have service and we have someone online. Could you get her on the screen now? Oh, okay. Could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
Good morning. My name is Angela Reimer. I am counsel for William Rutter, and my office address is 8875 Hidden River Parkway in Tampa, Florida.
Thank you.
Ms. Hull?
This is case L 205895. Krista Hull with the Development Services Department. Property owner and violator is William Rutter. Violator also is Jimmy's Tree Service Incorporated. Violation address is 16117 West Lake Burrell Drive, Lutz, Florida. Violation observed is unpermitted removal of 17 trees, which compose of oak, podocarpus, cedar, ranging from 12 to 20 inches DBH for a total of 276 inches. Ordinance violated is section 4.01.03.a. First inspection, February 3rd, 2020. First notice, February 5th, 2020. Last inspection, October 19th, 2021. 3 inspections conducted. The inspector evaluated the property and compared aerials of the property, one taken in February of 2019. The clump of trees that are circled are the trees that are missing in March 5th, 2020's aerial. The inspector was on the property February 3rd, 2020, noted that a new or a permitted garage had been built and trees were removed. On the last inspection, a recheck was made of the property and no new trees were restored. The property owner was noticed the first violation in February 2020, second violation February 5th, 2021, and was issued a notice of hearing by citizen board support. Jimmy's Tree Service had been attempted delivery of notices at 4 different addresses. None of the addresses were able to confirm a valid residence or business for Jimmy's Tree Service. It was also noted that Dylan's Tree Service was involved and the address that was provided was undeliverable. So after attempting multiple times, the violation is in the hands of the property owner to resolve. Staff recommendation is that the property owner plant or donate 276 inches DBH of approved shade or ornamental restoration trees, or contribute 276 inches to the restoration fund, or a combination of plantings and contribution to the fund within 90 calendar days. Trees must be 1 inch DBH or larger, a minimum 8 feet in height, Florida grade number 1, chosen from Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per inch. The property owner, William Rutter, will be responsible for resolving this matter with the county. Fines will be issued for failure to meet the timeframes.
Okay, Counselor, what would you like to tell me?
Your Honor, I just want to state we've been working with Ms. Hull since we were first noticed of this hearing. We have tried to reach Jimmy Tree. It appears that they have gone out of business, and I've discussed with my client. Ms. Hull and I have discussed this several times, and my client understands that he's responsible, even though he was told by the tree company that permits weren't necessary. So he's learned a very valuable lesson from this experience. My client and I have discussed the recommendation made by Ms. Hull, and we are prepared to proceed with that. Mr. Rutter has contacted Mr. Dickerson. We've obtained the tree list, and he's already making efforts to obtain those trees and have them delivered within the 90-day time period. So we would just ask that you do go along with Ms. Hull's recommendation, and we will be able to get that accomplished as soon as possible.
Okay, terrific. I'm sorry, that's a tough lesson to learn for your client, so I'm sorry to hear that.
Yes.
But I agree with the recommendations, and I'm happy to continue that with that timeline.
Thank you, Your Honor.
Absolutely. I rule in case L 205895 that based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances as listed in staff's presentation. Further, based on the gravity of the violation, the action taken by the violator and the violator's history, I concur with staff's recommendations, require the violator to plant or donate 276 inches DBH of approved shaved ornamental restoration trees, or contribute 276 inches of DBH to the restoration fund, or combination of plantings and contribution to the fund within 90 days. Trees must be 1 inch DBH or larger with a minimum of 8 feet in height. Florida grade 1 chosen from the Hillsborough County approved tree list as appropriate. Contribution to the fund equates to $65 per DBH inch. Property owner William Brudder will be responsible for resolving this matter with the county. Fines for not achieving all timelines above will result in a fine of $200 per day. Excellent. Counselor, you have your 90 days, and after that, it's $200 a day.
Thank you very much.
Thank you. Have a great day.
Next case is number 3. I'm sorry, page 3, number 6, L206413. This case complied November 1st, 2021. Page 4, number 7, L216575. This case was pulled per staff. Number 8, L216583. This case complied October 28, 2021. Page 5, number 9, L216605. This case was pulled per staff. Number 10, L216607 complied October 25, 2021. Page 6, number 12, case number L216708. The owner is Davia Wesley. Location 7736 Carriage Point Drive. We have service and no one is present.
Krista Hall with the Development Services Department, case L 216708. Property owner and violator is Wesley Davia. Violation address is 7736 Carriage Point Drive, Gibsonton. Violation observed: improper pruning resulting in the effective removal of a required lot tree and street tree for Carriage Point subdivision. Ordinance violated section 6.06, first inspection, March 5th, 2021. First notice, March 8th, 2021. Last inspection, October 26, 2021. 3 inspections conducted. The inspector found the trees missing, but on the Google image, you can see the effective pruning that is effectively removing the health and quality of this tree. The one up front, of course, is the street tree, and the one over towards the side is the lot tree. October 26 shows that the trees are actually not really sprouting much better. There's a few epicormal water sprouts coming out of the top of these trees, but they still meet the definition of effective removal and require replacements. Staff recommendation is that the damaged trees be removed and plant 1 county-approved lot tree and 1 street tree within 45 days as required for Carriage Point subdivision. Trees must be a minimum 1 inch DBH, diameter at 4.5 feet or larger, 6 feet in height minimum, and a Florida grade number 1 chosen from the Hillsborough County approved street tree list. Fines will be issued for failure to meet the timeframes.
Just for clarification, the lot tree has to be 1 inch DBH at 4.5 feet,
Yes.
6 feet in height, and then the street tree just has to be grade 1 off of the list?
They both need to be at least 1 inch in diameter or larger, 6 feet in height, and Florida grade number 1. The street tree list is a shorter list due to the public right-of-way requirements.
Okay, understand. Thank you. I rule in case L 216708, the based on the evidence presented, I find the property is in violation of Hillsborough County codes or ordinances listed in staff's presentation. Further, based on the gravity of the violation, the action taken by the violator and the violator's history, concur with staff's recommendations, require the violator to remove damaged trees and plant 1 county-approved lot tree and 1 county-approved street tree within 45 days as required for Carriage Point subdivision. Trees must be 1 inch DBH diameter at 4.5 feet or larger, 6 feet height at minimum, and Florida grade 1 chosen from the Hillsborough County approved street tree list. Failure to meet any of the timelines above results in a penalty of $200 per day. Next case, please.
Page 7, number 13, L 216711. This case complied November 1st, 2021. Page 8, number 15, L 216816. The owner is Michael, Derek, and Marie Porter. This case was pulled for staff. Page 9, under that was the end of the landscaping and natural resource cases. Page 9, number 17, under Public Works, Public Utilities cases. Number 17, ROWV 21008. This case complied November 1st, 2021. Number 18, ROWV 21009. This case was pulled for staff. Page 10, number 19, case number ROWV 21010. The owner is Ricardo Ramos. Location 14512 Knoll Ridge Drive. We have service and no one is present.
Good morning. Vicki Baker with Right-of-Way Inspection, Public Works Construction Services. If I could have the PowerPoint put up on the screen, please. This is case, excuse me, this is case ROW-21010 with the owner name of Ricardo Ramos. The violation address is 14512 Knoll Ridge Drive, Hillsborough County, Florida. The violation is unpermitted alteration within the Hillsborough County right-of-way. Ordinance section violated Hillsborough County Section 92-22 and the Hillsborough County Rights-of-Way Use Procedures Manual. First inspection was conducted on February 1st, 2021. First notice was sent on February 3rd, 2021. Second notice was sent on May 5th, 2021. Affidavit of hearing was posted on site on October 19th, 2021. Last inspection was conducted on October 26th, 2021, with a total number of inspections of 4. Next page, please. Can you go to the next page, please? Yes, ma'am. Apologize for the delay. This first screenshot, Magistrate, is of the residence back in February of 2018, which shows the current condition of the right-of-way. Next page, please. This next view is of the February 1st inspection with the removal of the apron, the impact to the sidewalk, and also subsequent clearing of the site, although we're more concerned with the area between the back of walkway and the back of curb. Next slide, please. This would be right of the residence on the same property. Same situation on this February 1st inspection of all of the green belt being removed and then impact to the sidewalk as well. Next screenshot, please. These photographs were taken on the second inspection, which shows that the green belt has been placed back, but subsequently a unpermitted driveway apron has been installed, and there's evidence of parking on that specific pad or apron, which is in violation of county code due to obstruction. Next slide, please. Again, to the right of that location in front of the residence, where you can see the addition of another apron. And next slide, please. And then this is looking down along the sidewalk where you have the apron that's been installed, damaged walkway, and drop off. Next slide, please. Just a little better view of the damaged walkway along in front of this residence. And next slide, please. And that just shows you the continued impact that we have there. Next slide, please. So staff recommendation would be to coordinate with staff and complete the right-of-way permitting as required for the removal and replacement of concrete aprons and damaged sidewalk. This right-of-way permitting task must be completed and issued within 30 days. And then subsequently, once the right-of-way permit is issued, the construction completion of the removal and replacement of the drive aprons and sidewalks will need to be accomplished per the permit conditions. And this construction task must be accomplished within the 30 days of the right-of-way permit issuance.
So this recommendation and violation is only in regards to the right-of-way, doesn't have anything to do with the impact of removal of the front yard and created a concrete island to park 6 vehicles on?
No, sir. It's a right-of-way violation. The on-site manipulation of the site would be covered either under natural resources or code enforcement.
Okay. Have we had any communication with the owner?
When we posted the notice of hearing, the owner was on a cellular phone, and he did state that well, let me back up, sir. I know that there's history that he has tried to do the permitting, although he did not follow through with the permitting. And that's when we continue the process of the code enforcement hearing. And subsequently, when I delivered the notice of hearing, he was on the phone, but really, I just had indicated we're just citing you for the hearing unless certainly he didn't move forward with the permitting, continue with that process. So he basically was served.
Excellent. Thank you.
Yes, sir.
I move in case ROWV 2101. The basically, Mr. President, I find the property is in violation of Hillsborough County codes or ordinances as listed in staff's presentation. Can you bring that recommendation back up for me, please? Further, based on the gravity of the violation, the actions taken by the violator and the violator's history, concur with staff's recommendations, require the violator to complete the right-of-way permitting that is required for the removal and replacement of concrete aprons and damaged sidewalk. This right-of-way permitting task must be completed and issued within 30 calendar days. Once the right-of-way permit is issued, the construction completion of the removal and replacement of the drive aprons and sidewalks will need to be accomplished per the permit conditions. This construction task must be accomplished within 30 calendar days of right-of-way permit issuance. Failure to meet any of these timelines result in a penalty of $500 per day.
Number 20, case number ROWV 21012. This case complied October 29th, 2021, and that completes the agenda.
Excellent. Thank you, ladies and gentlemen. Thank you to everybody online that helps make this happen. This meeting is adjourned.